This is Duke University.
Everyone, sorry to cut you off. Let's go ahead and get started. I'm Kara Duffle, the editor-in-chief of the Duke Journal of Constitutional Law and Public Policy, and I want to welcome you to our 2012 annual Spring Symposium, The Consequences and Constitutional Dilemmas of State Debt. Our goal, well, first I want to thank you all for being here today, and I'd also like to thank our very generous co-sponsors, the Federalist Society, Sutherland, Aspel, and Brennan, the Duke Economics Center for Teaching, and the Duke University Political Science Department. I would also like to thank our wonderful speakers, panelists, and participants. Without you, there would be no symposium at all. So thank you all for being here. As a journal, our goal for our spring symposium is to create a forum in which to discuss, to analyze, and to understand some of the most challenging issues facing our legal community and more broadly our society as a whole. We hope that this symposium, with its presentations and panels, can foster a dialogue that will extend beyond this conference and that we can take with us as we face these problems in the future. This year's topic of choice is state debt. To set the stage for these discussions and to tell us all why state debt is and should be the subject of an ongoing dialogue is Professor Jim Johnson. Professor Johnson is a visiting professor of the practice of public policy studies at Duke's Stanford School of Public Policy. His particular areas of expertise include legislative and policy issues, budgetary policy and process, and state and local policy. Until December of 2005, Professor Johnson was the director of the North Carolina General Assembly's Fiscal Research Division, a staff dedicated to fiscal, budget, and policy issues. Now, in addition to teaching at Sanford, Professor Johnson is a partner at a Raleigh-based government relations and business consulting firm. With his experience as a scholar and a practitioner, Professor Johnson is uniquely situated to provide a broader context for this conference. Thank you all again for being here, and I will now hand the floor to Professor Johnson.
Well, good morning. Thank you, Kara, for that very generous introduction, and I'm especially thank the group for your kind invitation to open this symposium today on the dilemmas and consequences of debt in the American states. Kara said that I was in a government relations practice. For many years that I was at the General Assembly, my mother would constantly ask me, and she turned 92 in January, what is it you do over there? I mean, it was never very clear to her what being in the Fiscal Research Division meant. And then I told her I was becoming a lobbyist. And she really, really understood what that was and probably hasn't forgiven me since then. You've got a group of speakers today and papers before you that I think take on the issue of state debt in some very provocative and challenging ways. They offer analysis, and they should provoke your questions on what I think is becoming one of the most challenging issues confronting the American states. Before our speakers present their perspectives on state debt, I'd like to give you a very personal set of impressions about what I believe are some of the contributing factors that we're going to analyze in these papers. Let me say that up front, I'm not presenting in these remarks something that constitutes the well-reasoned policy analysis supported by quantitative and qualitative data. So for my Sanford students who were here, at least one of them, apologies. That's not what I'm trying to do. Instead, I'm going to try to make some points by telling a couple of stories. In the South, we like to tell stories, as some of you know, but stories, I think, are one way that we train new policy analysts and the way that we train lawyers. At Sanford, we call stories case studies. At law school, you call it case law. But all good cases begin with a story. And some of these stories are true, and some of them maybe not so true, but they probably should be, okay? So let me begin with what I call the case of the sorry nephew, okay? Sorry, is for those of you who didn't grow up in the South, has a very particular meaning to it. It's what Kara's mother said about one of her friends or her grandmother. I think that person is sorry. It connotes the sort of thing that's just not appropriate given whoever your family was. It's also kind of at the same level of the phrase, bless her heart, which has its own particular special meaning. It is, they are, in legal terms of art. Okay. So let's imagine, if you will, that it's the late 1950s, maybe the early 60s, late afternoon, right around Thanksgiving time, in a large Wall Street investment bank. The market's closed, and two of the very senior partners are in a meeting, and the conversation is going something like this. John, you remember my sister's son, William? Yeah, I do. He's named after you, right? Yep, that's right, that's right. He's a sophomore at X, and the partner names a very prominent Ivy League school. Well, William has gotten into a lot of trouble and needs to drop out of school at Thanksgiving. Too much drinking at the fraternity house and not enough hitting the books. There's nothing sorry about the boy. He just won't buckle down and study. He just can't seem to grow up. I was wondering if we could put him down in the fixed income department, maybe in state bonds, until he can reapply to the university next fall. The partner says, Bill, you're my closest friends. Of course we can do that. Besides, nothing ever happens down in that trading desk. The boy will be so damn bored, he'll be rushing to reapply to the university in this fall. What happened? How did a sleepy backwater of state tax-exempt and local bonds become the issue that it is today? My next impression, this one more true. And I call this, would you like some bonds with your iced tea? Okay. In the mid-90s, late summer, I'm in Maine at a legislative conference sponsored by the National Conference of State Legislatures. I'm in the line at a lobster roast, and the person next to me introduces himself as an investment banker from Philadelphia. That should have been my first clue, Philadelphia, okay?
Investment banker.
And an investment banker. We exchanged cards, and he next says a phrase that has stuck with me since then. Has North Carolina begun to securitize its iced tea funds? Well, at that point in time, I was dealing with a lot of K-12 education policy in North Carolina. But I did know that he wasn't talking about North Carolina sweetened iced tea. Rather, that iced tea was shorthand for the federal highway spending, or, you don't know who invents these things, the Intermodal Surface Transportation Efficiency Act. Okay? It's like some of the other phrases that investment bankers have invented. He then went on to tell me that Congress had passed laws that allowed states to issue bonds or securitize their stream of future federal appropriations. Think about that for a second, okay? We now call these Garvey bonds with the great phrase, grant anticipation revenue vehicles. Some of you will be running into these before long. They're issued by North Carolina and a number of states. So where did all these new investment instruments come from? My next story, we'll call this moral hazard. What moral hazard? In 1998, a hedge fund called Long-Term Capital Management in Greenwich, Connecticut, where else, with two Nobel Prize winners on the board of directors, implodes after making a series of highly leveraged investments in various types of equity and fixed income instruments or bonds. At the peak, Long-Term Capital's investments, counting their derivatives, topped $1 trillion. After LTC incurred these enormous losses, the Fed, led by the Bank of New York, stepped into the situation and basically bailed them out. There are a lot of folks out there who think that what happened at long-term capital was sort of the canary in the coal mine for the events that unfolded later in 2008. Okay. We'll call the next story "The End is Near." On December 19th, 2010, some of you may remember that Meredith Whitney, a prominent Wall Street analyst, goes on 60 Minutes and declares that the problems in the states and in the municipal bond market, the local bond markets, are so serious that we're going to see hundreds of defaults and billions of dollars worth of defaults in very short order. Between October 2010 and January 2011, over $30 billion exits the municipal bond funds. Ms. Whitney's dire predictions have not come true as yet. Otherwise, we would be in debt restructuring conversations in this country that probably more closely resemble what's going on in the EU right now. Okay. What changed over the past 30 years that turned this kind of quiet backwater of sovereign debt and U.S. state debts into something that more closely resembles the other dynamic and relatively volatile fixed income markets? A couple of thoughts on this. First of all, today when we think about state debts, the definition is broadened beyond just bonded indebtedness, and some of those types of bonds have also changed, okay? Now we talk about things like unfunded pension fund liabilities, retiree health care liabilities, and state borrowing. This one is very under the radar, that has occurred during the Great Recession against the federal unemployment trust fund that were used to pay unemployment benefits and are now coming due. The state pension and health care cost, both of these issues have received a lot of discussion and conversation in the press. I would argue that may be substantial confusion still about the issue. One of the best reports done by the Pew Center on the States pegged the gap at what the states and the localities have promised versus the assets on hand at about $1 trillion. While this picture has somewhat improved with the financial markets in the last year, it's still a good gauge of the size of this problem. So what we think about as debts have changed. The other thing that's changed, and it relates to my little story about the iced tea bonds, are the types of investment bonds, debt instruments out there. When I went to work in the legislative staff in the early 70s in North Carolina, when people talked about state debt, local debt, they really meant general obligation bonds and revenue bonds. To the points today, the issuance of what, let's call them GOs for a second, shorthand, and revenue bonds are usually governed by your state constitutions and a thicket of statutory law. There's lots of statutory law around this. The concept underlying the GO bonds are pretty simple. The legislature makes a decision on the debt, and the citizens get to vote on to approve the debt, because behind that debt stands the full faith and credit of the state or the taxing authority, if you will. GO bonds, most generally, have been used for infrastructure, university buildings, highways, community colleges, things that you can touch, okay? And they're revenue bonds. And revenue bonds are generally very narrow purposes, and they go to do there's usually an infrastructure project. There's some revenue generated by it, and the revenue is used to defease the bonds or pay off the bonds. The best example that you deal with every day is a parking deck. Lots of parking decks are built with various kinds of bonds. In the past 10 years, we've seen, or longer than that, a profusion of new kinds of debt instruments beyond the plain vanilla GOs and revenue bonds. Generally, the characteristics of these new debt instruments, the thing they share in common is that they don't have the approval, the voter approval of the GOs. And at least on paper, do not represent the full faith and credit of the states. The reason why local and state governments do these non-voted debts are complex and kind of beyond our conversation today. And it's not always the obvious reason of avoiding a voter referendum. The paradox is, in the market, at least for the last 10 years, is that these non-GO bonds, which presumably, since they are not full faith and credit and carry more risk, trade at only a slight premium in interest rates above the GO bond, okay? Something is going on. Okay, a short list of these, and these are all kinds of acronyms, but for those of you in finance, you'll run into this. They're COPs, Certificates of Participation. In North Carolina, we have something called Special Indebtedness Bonds. The Greve bonds that we just mentioned, this grant anticipation revenue vehicle. There are a variety of revenue bonds. At the local level and in other places, you find something called tax increment financing, TIFs. And then we also have, in some places, North Carolina being one of them, revenue anticipation bonds. And these are unvoted GOs. And you have to kind of root around, if you will, in a Southern expression, in the North Carolina Constitution and the statutory law to find out that there's an authorization for something called revenue anticipation bonds. The conclusions I've reached over the last 10 years is that if there is a stream of payments and revenues, smart investment bankers and lawyers, some of which you're going to become, will figure out a way to securitize it and issue a bond, okay? We have seen that these new debt instruments will be subject to the same sophisticated trading and financial management strategies that you see with other kinds of debt instruments. And for examples of that are options trading and things called interest rate swaps. Crowding out, an issue that is some concern to members of your panel. We have to confront the possibility or even likelihood that existing debt costs can or will crowd out spending for other state needs, such as education, social expenditures, and new infrastructure projects that are necessary for future economic growth. The crowding out is most likely to be painful in times like we're in today, where there's a combination of insufficient economic growth to support the debts and an inability politically or otherwise to raise additional revenues through the tax code. Given the problem of the unfunded liabilities, the multiple debt instruments, and the potential for higher market volatility around these tax-free debts, and tax-free debts that were once really stockpiled by the trust departments and banks for their customers. What are our paths forward? What are the possible paths forward that, in my opinion, do a couple of things? One, protect the state's ability to raise money and invest in the future. Give some assurance to investors that they're going to get their principal and interest payments made. Some assurance. It doesn't have to be 100%. And finally, to deal with what may well be, in the minds of some presenters and in the long-term capital example, the problem of moral hazard, as economists call them. That may be the moral hazard problem embedded in our current system. So these are some of the issues that bring us here today. And like you, I look forward to hearing from the presenters, and thank you for the opportunity to come and speak with you.
And Professor Sachs is going to moderate the first panel, and I think someone else was supposed to introduce you. I'm so sorry, but
no worries. I require no introduction.
He's possible, and he's wonderful, and yeah, our first moderator.
Thank you very much. I don't know if the mics are on or not, but yes. Hopefully I can speak loud enough to be heard. Good morning. My name is Stephen Sachs. I'm an assistant professor here at Duke Law School, and I'm glad to have the opportunity to moderate the first panel of the Symposium on Policies, Proposals, and Practical Implications. We're honored to have three distinguished scholars with us today. In no particular order, since I'm not sure in quite which order they'll be speaking, but in the order they've been seated. Peter Conti-Brown is a law clerk for Judge Gerard Lynch of the U.S. Court of Appeals for the Second Circuit. Next year, he'll be clerking for my old boss, Judge Stephen Williams of the U.S. Court of Appeals for the D.C. Circuit. Previously, he was an academic fellow at the Rock Center for Corporate Governance of Stanford Law School. He writes about banking, bankruptcy, corporate, and administrative law, and has written numerous recent articles on financial risk. His paper discusses the fiscal consequences for states of adopting constitutional amendments by referendum and suggests a possible solution for the political deadlock that can result. Michael Greve is the John G. Searle Scholar at the American Enterprise Institute, as well as the chairman of the Competitive Enterprise Institute. His work focuses on constitutional law, courts, and the regulation of business. He is the author of numerous books, including most recently The Upside Down Constitution, which will be published this year by Harvard University Press. His paper today looks at the history of the federal government's commitment not to bail out indebted states and asks whether that commitment can continue into the future. And finally, Jean Nichol is the Boyd Tinsley Distinguished Professor of Law at the University of North Carolina, as well as the director of that school's Center on Poverty, Work, and Opportunity. Previously, he was president of the College of William and Mary and is a former dean of the law schools of both UNC and the University of Colorado. He writes and teaches about issues of constitutional law, federal courts, and civil rights. His paper addresses state budget deficits in a comparative light with reference to other serious problems facing the states, in particular high levels of poverty. Thanks very much to all three of you for coming today and to all of you for joining us. Each of the speakers will have about 15 to 20 minutes to present, after which I'll open the floor for questions. So, Mr. Conti-Brown.
Great. Thank you very much. So before, kind of an annoying word about my affiliations and bio. I am a law clerk on the Second Circuit and continue to be a fellow at Stanford. I'm here only in my capacity as a fellow for Stanford Law School, and as it's silly to have to say, but I have to say it. Nothing that I'm going to say reflects at all on the Second Circuit, and in particular, my judge, who very graciously allowed me to come down here, though has certainly not even read a draft of what I'm presenting, so it certainly doesn't reflect on him. I'm delighted to be here, and I appreciate very much Professor Johnson's introduction. I'll be touching on some of the themes that he discussed, particularly moral hazard, but of a different variety. The usual story about bankruptcy, and perhaps why as a heuristic it's been so appealing in conversations about state fiscal crises, is that there's a problem of excess debt that can't be handled or paid or eliminated in its usual way, and there should be some sort of structure or mechanism by which that excess debt could be treated. I'll talk a little bit about that issue in my paper, but I want to focus on a different kind of problem in state fiscal crises, and that's a problem of excess law. And in particular, what I mean by that is excess fiscal law. In states that allow them, popular referenda are nearly always controversial, almost by definition. There are very few that win by supermajority vote, for example. You may have heard of one in California. I believe it's called Proposition 8. It's made a few headlines recently. But popular referenda don't only affect social policy, they also affect fiscal policy. And even some referenda that do affect social policy have fiscal impacts. Now, the economic historian John Wallace has described, he's termed what he calls fiscal constitutions. And there are these mechanisms attached to constitutions that dictate some aspect of fiscal policy. These might be a requirement that the legislature can't pass taxes without 2/3 vote, or can't pass a budget without that vote. What I'm interested in are popular referenda that are themselves fiscal constitutions. So those that dictate a fixed percentage of a budget must be allocated to a certain cause or certain area, regardless of what the economic circumstances may be, or if it takes into consideration outside economic circumstances and only adjusts slightly. Another example might be, and this is a real example from California, a recently passed referendum that prohibited the state government from quote-unquote borrowing from local tax revenue streams, which presents a fascinating kind of question about what exactly a local government is vis-a-vis the state government, but that prohibition is in place in California. And another example is are hard limits on increases in property taxes, which again is a controversial but part of the California Constitution. So the question then is, what occurs in the event that there's too much fiscal constitution. It prompts a crisis. Now, I'm taking that for granted, and I shouldn't. That's actually a very interesting area, and someone with the methodological skills and interests could study this. In my knowledge, it's not been studied. The extent actually that these states with popular referenda are themselves burdened by these things that could precipitate a crisis. Now, this essay that I've written assumes that to be true, but I want to flag that because that assumption is only for the purpose of this qualitative model. I don't think it's been proven. But assuming that that's the case, that you've got then a legislature that has to deal with fiscal crises, but with one hand tied behind its back. It can't make use of all of the revenue streams available to it because of the Constitution. So that's aspect one of the problem. Aspect two is the moral hazard that Professor Johnson talked about. Now, political scientist Jonathan Rodden talks about fiscal federalism and the moral hazard that results in federations. He looks at both the U.S. and also the European Union, but it exists anywhere that there's a federation, including trade agreements that carry with them, either in the form of a common currency or a common form of government or in other ways, an implicit guarantee between the federation and the subgovernmental entities. And Dr. Greve is going to talk more about this question. But there is a question of moral hazard in the state context, namely that the extent that a state government becomes overly indebted and faces a crisis and can't meet its payments without the kind of mechanism that's been discussed by scholars of state bankruptcy, an obvious solution is to turn to the federal government and say, we need help, you need to cover these debts. Now, of course, the moral hazard here is an obvious one. To the extent the government says yes, then there's a dampened incentive for the state actors to cover their own debts as they come due. The idea is that they'll get all the benefit from taking the loans and then be able to put the costs onto the broader federation. So what do we do in this scenario? And so here's my proposal. And I'll have to start with a note of forced modesty and say that this essay is a great example of a symposium essay that tries out a half-baked idea to sample the recipe. I hope you like the recipe, but I'm looking forward to your challenges on this because I think this is a bold proposal, and I think it needs to be birthed in an academic context before it could be bandied about in a policy one. So the proposal is this. Out of respect for state sovereignty, but out of a need both to clear this excess law as opposed to excess debt, and to mitigate the likelihood of moral hazard, I would think that something like the financial review boards, sometimes called financial control boards, that exist in the municipal bankruptcy context might be tried in the state bankruptcy context. Again, state bankruptcy meaning state fiscal crisis context. So the financial review board is when a municipality goes bankrupt. Frequently the state, who is the sovereign here, the municipality is not the sovereign, but a subgovernmental corporation, will say, okay, fine, you can file for bankruptcy under Chapter 9 of the Federal Bankruptcy Code, but in order to do so, we're going to impose a financial review board that's going to say, you got to do X, you got to do Y, you got to change your payroll, you got to change your pensions, you got to do this, you got to do that. There are obvious federalism and sovereignty concerns of doing that on the state level, but here's the way that I think that might be done. Using the popular referendum to combat the popular referendum. And the proposal would be for a popular referendum to get on the ballot that declares a state of fiscal emergency. And that declaration then calls into form a previously authorized federal, what I call in the paper, a Fiscal Restoration Commission. And the Fiscal Restoration Commission is a creature of Congress which ties the acceptance of federal bailout money to a state with the acceptance of a proposal from this commission. So, in other words, there are three statutory mechanisms at play, two state and one federal. The federal, again, is to create this thing, to declare it as the intent of the U.S. government not to meet the debt demands of its individual states, unless they accept the proposals offered by a Fiscal Restoration Commission. And the paper contains details about how that would be appointed and what ways that you could use elements of institutional design and institutionalized independence in order to increase the likelihood of a nonpartisan unanimous proposal. Second statutory authorization is the state that, again, declares the fiscal emergency by popular referendum. and calls into being a specific, say, California-based fiscal restoration commission. That first initial state authorization by referendum acknowledges that that seeking federal funds for the purpose of covering state debts is contingent on accepting in toto the FRC's proposal. The FRC then does its work, creates a document. I imagine it would be several hundred, if not 1,000 pages long, and it would have in its proposals, it just as kind of an armchair proposal to say this constitutional amendment needs to go. This statutory authorization has to go. This constitutional amendment has to be changed. It's then presented. Now, this, of course, depends on the state. In the state in question has the ability to change the Constitution by popular referendum. But when it does, the third statutory authorization is both a statutory and a constitutional one, which is the acceptance up or down, is the acceptance or rejection in its entirety of the FRC's proposal. And again, this is the controversial aspect. This proposal, which will be a yes or no single referendum, will change the fiscal legal landscape of the state in question. And in a word, clearing the excess law. So that's the proposal. I'm hoping that the gears are already turning about why this proposal can't work as a matter of constitutional law. As a business law scholar who only dabbles in constitutional law to the extent that it's relevant to my areas, I'm sure there are things that I'm not looking at. The benefits here, though, are several, and it would include, one, this waits for a crisis to occur. I'm agnostic on the point of what so many scholars, including my co-editor David Skeel, is advanced on state bankruptcy, whether or not this really is a solution looking for a problem. What my proposal is, I think explicitly, is a solution looking for a problem, or perhaps better, a solution waiting for the problem. And that problem has got to occur in the sense that you've got enough of a groundswell popular demand to say, this can't happen anymore. It's not just we're sick of the excess debt, we've got too much debt, even as we're paying it. Macroeconomists debate at great lengths. One of the most controversial aspects of ideas in economics is what percentage of GDP debt an industrialized economy can sustain. This will wait until that by a majoritarian democracy says that crisis has come. We are here. Another is that it provides both political cover and political ease in order to make hard calls. Now, this is something that's come up in the municipal bankruptcy context, where the financial review boards in municipal bankruptcy, I'm thinking especially Philadelphia in 1991, one of the reasons it was so successful is that there were no really new ideas in what they were proposing. It's just that some of them were politically unpopular on both the left and the right, and that being able to appoint a delegee to navigate these waters was exactly what the politicians wanted and just couldn't muster. That's the perhaps a little bit cynical version of the story. A different version, perhaps also cynical, is just simply that in some cases, representative democracy and direct democracy aren't very effective at dealing with fiscal problems, and that a delegated commission might be better. Also, shows respect for the state's sovereignty in a way that state bankruptcy doesn't always do. This is a state-authorized, state-accepted mechanism. It can't be done from top down. It can't be imposed by the federal government. The Constitution was only amended by the state sovereign. Here would be the people themselves. And then last benefit, I think, is that this cuts at the roots, not just at the branches of what may be a problem. Problem of clearing out excess debt in a state bankruptcy context is that the excess debt could respring from the apparatus that's already in place in those states. So if the problem is too much debt and you clear that away, then just like General Motors or any number of airlines, they will come back. Chapter 11 is sometimes a very comfortable place for these corporations to be. It's not clear, and this is a different version of moral hazard, it's not clear that state bankruptcy would be any different. Here, this would be a radical reshaping of the fiscal landscape for the state in question. Now, how am I doing on time?
Perfectly.
Okay, so I will just flag the counter-arguments without discussing them. One counter-argument might be that there is just no federal authority to do such a dramatic thing, and I think that's wrong. I think the spending clause jurisprudence is pretty clear that the federal government can condition its payments to states, and I think this is well within the scope of Dole against South Dakota. Another is that this isn't better than state bankruptcy. And what I would say is this doesn't replace state bankruptcy, but complements it. Again, it's a different question. It's a question of clearing excess law as opposed to clearing excess debt. And I would think that some, including Duke's own Stephen Schwartz, have proposed pretty elegant solutions to the debt issue. Mine's not getting at that. And then the other is simply these kinds of pre-commitments have been tried and don't work. I'm very persuaded by this. I think what this does is just increase the political costs of bailout, even if it doesn't eliminate them. And the last is a critique that I think it really cuts at the heart, and I think Professor Nichols will probably get to this a little bit more. Part of the problem here isn't state, it's federal. Unfunded mandates, the subordination of what had been federal governmental fiscal concerns to the states without the states having a capacity to deal with such. That this, in other words, state fiscal crises are a creature of the federal government, not the state. And to that I say that's a pretty compelling argument, and I would want to know more about exactly to whose feet we would put the blame for these kinds of situations.
Thank you very much. Dr. Greve.
I'm not a finance guy, but some stuff in finance strikes me as inherently funny. Among those things is the notion of the risk-free rate of return. Sometimes supposed to be, if you buy sovereign debt, that can't go wrong. That's risk-free. Sovereigns can't go bankrupt. No, sorry. Everybody can go bust. Everybody does go bust. What there is a return-free rate of risk. And thanks to Ben Bernanke, we know what it is. But other than that, everybody can go bust. Except they go bust in different ways. Federal systems suffer, and all roads eventually lead back to Stanford. Peter has already mentioned John Rawdon, I'll mention him too. Federal systems suffer inherently from moral hazard, that is to say, junior governments will overspend and borrow, and in the hope or expectation of a federal bailout. There are only two ways, so long as you maintain a federal system, there are only two ways to combat that tendency. One is a credible pre-commitment against bailouts. You have to demonstrate that. You cannot just say so. And the other option to deal with it is to sort of eventually bail them out, but make it so painful that other people will think twice about going through that same process. This is basically Chancellor Merkel's prescription for the EU, right? What they're saying to Greece is, fine, we will drum you through an austerity program that'll make your teeth rattle, and we will run your miserable little country from the Reichskanzlei for a few years and see how that suits you. And the problem that American federalism now faces is that that isn't really an option for us. And the pre-commitment against bailouts has collapsed. That pre-commitment, we won't bail out states, has been one of the most striking and salutary features of American federalism throughout its history. It's historically conditioned in the 1840s. Several states went bust and defaulted on their debts. Those debts were owed to foreign creditors, mostly in London and Amsterdam. And the United States government said, sorry guys, suck it up. For 1 year, America was completely cut off from foreign credit. The creditors soon returned, and everything went back to normal. And one of the things that we learned from that is the feds won't bail out states. They didn't do so after the Civil War, and they did not do so during the Great Depression. As I said, that pre-commitment against bailouts is now breaking down, has already broken down. I'll come back to that point. What are you looking at here? Well, you're looking at $2.8 trillion in municipal bonds outstanding. As you've heard from Jim, more and more bonds are getting more and more exotic, and they're not always for infrastructure projects anymore. You're looking at a crumbling infrastructure and chronic underinvestment in infrastructure over a very long time span by now. Why do we have that? Answer, there's this crowding out effect. We need the money for ongoing obligations such as Medicaid and we need it to pay public sector pensions. There are, Jim mentioned the Pew estimate of $1 trillion. There's studies from Northwestern universities that say it's more like $4 or $5 trillion in unfunded obligations out there. Hangs on the discount rates with which states operate and what you think is realistic there. There's about $500 billion in completely unfunded obligations for health benefits in the public sector. One of my office mates at the American Enterprise Institute is a banker, and he has what he calls Alex Pollock's first law, which is debts that cannot be paid will not be paid. And you can take that to the bank, so to speak. So how is this problem going to play out? There was, as you've heard, so a year ago, when Mrs. Whitney or Ms. Whitney went on TV and said, oh, you know, we're going to have all these defaults. California will be like Greece, except it's several times larger. I don't think the European Union is actually a fair comparison because there are far too many institutional differences between them and us. Here's the first one. Their debt is actually held by banks as capital, against which they then issue, which they then leverage. We mercifully don't have state banks that are big holders of state debt, which they then leverage, and which, when it goes bad, can take down the entire financial system. If there were a Bank of California that operated like the Deutsche Bank or Banco Santander, that would be a real problem. Mercifully, the debt that's out there state-wise is held by individual investors, people who hold municipal bonds, mostly tax-exempt bonds for the tax advantages, some funds like PIMCO. If those go bust, well, that's too bad, but it'll be like long-term capital. It's a hiccup, and it is not a systemic threat to the system. Again, if we had the European form of organization and the form in which the debt is held, we would have their problems, I think, but we don't. That's not a reason to say, hurrah, hurrah, we're better. I'll come back to that point. The second point is that the remedies will be very different. Unlike the European Union is sort of Hamilton's worst nightmare. It's a government over governments, and that government can do an awful, the supra-government can do an awful lot of things to its junior governments. Among other things, Mrs. Merkel can call the president of Italy and say, you must fire your prime minister or else, and he promptly complies. We cannot do to California what Germany is doing to Greece or Italy, and that's a good thing. And the third difference is that the European Union is not a transfer union. That is to say, it doesn't have this arrangement that we have and that many federal systems have, which is a combination of central tax authority and local spending authority. The EU has no central tax authority that's worth mentioning, and so therefore it has the problem in a slightly different configuration. We are a transfer union, and that drives our problems, and that drives the range of solutions, I think. The consistent finding in the federalism literature is this: a high fiscal imbalance, that is to say high transfer payments from the central authority to the junior governments, means more local overspending, more local overborrowing, more moral hazard. This is one of the reasons why the pre-commitment in the United States against bailouts has lasted so long. There weren't any federal transfer payments worth mentioning, at least not until the Progressive era and then the New Deal. We now have a very massive transfer system. Roughly 22% of state budgets are now funded from federal tax revenues and transfers. The ratio is much higher for some states, and it is much higher in some areas of public policy, especially Medicaid, where the fiscal imbalance is 60, 70, 80% in some states. For every $10 that are spent on Medicaid in a given state, $7 or $8 of that money comes from the federal government. That causes a whole lot of crowding out, and it causes an awful lot of debt. because for a long time these transfer programs had the effect that they were supposed to have, which is drive up local taxes or the willingness to tax. That is no longer an option. State and local taxes as percent of GDP have remained flat at 15% for more than 15 years now. That doesn't seem to be an awful lot of room on the upside anymore. So how do we deal with this? How has the system dealt with it? Well, the answer is we have bailed out states. We've done so repeatedly, except we don't call these things bailouts. We call them a stimulus bill. That was ARA. That was nothing but a state bailout. The federal government has issued now discontinued Buy America bonds, which are an explicit subsidy for the issuance of new debts by states. We've repeatedly bailed out states' Medicaid programs. This began under the Clinton administration with a program called S-CHIP for children, so that you could transfer children from Medicaid, which was already overburdened, into S-CHIP, which offered an even more generous matching ratio than than Medicaid itself. There was a drug benefit for the elderly under the Bush administration, which was a windfall net for most states with respect to Medicaid. The American Recovery and Reconstruction Act, ARA, also known as the stimulus, again provided for a temporary increase in Medicaid funding. That was once extended, that ran out last July. The biggest bailout bill of them all, which no one seems to recognize and comprehend, is Obamacare, the Patient Protection and Affordable Care Act. The first thing it does is for new Medicaid patients or populations, the FMAP is 100 cents on the dollar. The feds will pay all of the money and let the states experiment with who they want to cover under those programs. And the second thing, and this is even bigger, is once the exchanges under the statute go into effect, and that's the motor that makes the entire statute work. Once the state health care or health insurance exchanges go into effect, states will be able to transfer hundreds of thousands of their employees and retirees from their current Medicaids or from their current state-funded systems into the exchanges and into the new and improved Medicaid, and therefore wipe out the state obligations, the unfunded state obligations that currently loom over the states. Not that they account for them, but they do exist nonetheless. Those bailouts now, those sort of bailouts under any other name, have, I think, reached the limit. I think Obamacare illustrates that very dramatically. Even though the funding ratio is 100%, note that the states are litigating against it because they say the federal government is failing to assume the legacy costs of Medicaid and provide an even bigger bailout. Once you read Paul Clement's brief carefully, that is their position. And that's not going to happen for the very good reason that the feds are also broke. So now what's going to happen? I don't know what's going to happen, but I think sort of the appropriate metaphor here is entropy. The paper that I wrote has a long comparison to Argentina, which has our fiscal problems except in a more developed form. You will continue to see public underinvestments in infrastructure. You will see what what Argentina has already done, which is bailouts in the form of pension reform. That is to say, a transfer of state employees' pension obligations into the federal system one way or the other. You may in the future see the Federal Reserve purchasing state bonds, state muni bonds, maybe not directly, more likely by means of fiscal repression. That is to say, they just make phone calls to the Bank of America. Dear Bank of America, please buy more muni bonds or else there will be no more bank. It's the most convenient way of handling these things. That's how we disposed of the World War II debt. And the final thing that I think we will see sooner or later is we will inflate our way out of it. That's the Argentinian solution, right? They first rolled all the local pensioners into the federal system in Argentina and then said, guess what? You will get your pensions back, except we won't pay them in US dollars, we will pay them in Argentinian pesos. I think that is what will happen to our pensions too. We will all get our pensions paid except in the equivalent of Argentinian pesos. This is not an attractive scenario. Can one think of reforms? Yeah, you can actually think of reforms. Brazil, in fact, has successfully reformed its system a decade ago along the lines Peter suggested, not exactly in that form, but by means of a fiscal responsibility law that took a lot of authority away from their states or regions, and most importantly, shut down their state banks. Germany has a very efficient way of dealing with the risk of fiscal hazard. I'd be happy to talk about that, but I don't think actually any of those solutions will materialize in the United States, and here is why. For the Democrats, the fiscal transfer state is a way of supporting its constituencies, and in particular, public sector unions. Federal education programs fund education only incidentally. They mostly fund educators. Federal health programs fund health programs and public health only incidentally. What they mostly fund is the health care machinery. And you can ask a lot of the Democratic Party, but you cannot ask the Democratic Party to turn suicidal and to turn on these programs. That's just not going to happen. And on the Republican side, the picture is even grimmer because there is no limit to the extent to which conservatism in America has just deliberately gotten stupid. The program that the Republican Party has fought for since Newt Gingrich is devolution. We will devolve federal power to the states. And what that means is we'll give the states more freedom to experiment with federal dollars. Look around, that is Mitt Romney's program, that is Newt Gingrich's program, that is Paul Ryan's program. And my question is, are you out of your minds? You want to give these people more freedom to play with federal dollars, as if that is not the thing that has gotten us into this predicament in the first place. So I'm pessimistic, but if there's anybody out there who has any bright ideas, I'd love to hear them.
On that cheery note, we now...
By definition, I'm not going to speak at that point.
we now turn to President Nichol.
Actually, I'm going to stand up. I'm old. I am delighted to be here. It's good to see old friends. I'd like to thank Kara and the Journal for hosting this. It's always good to see the students dressed other than they are in their normal working days. And to listen to Jim reminding us that we are in North Carolina, after all, that stories, the sorry state bond expert, I love that term. You'll get to love it too. The equivalent, as you said, is bless your heart. I have a running debate with Lee Smith about whether bless your heart has to be a term of derision. In my family, it could also be used in an affirming way, but she says that it's proof that we didn't know what we were talking about. It is simply a term of derision. I have to say, coming over from my country, that this is a tough week to be here after Wednesday night, February 8th, a day along with December 7th that will live in infamy, the date of the most heartbreaking basketball game in American collegiate history. Not your view, I guess. Proving again that many visions of truth are relative. I will say, before I moved to North Carolina 15 years ago, I had what was perhaps a modest, merit-based respect and affection for Duke University. So that I believe that when Duke and Carolina weren't actually squaring off against one another, that I could wish the Blue Devils Godspeed. Let me just concede in retrospect what a naive, childish, and uninformed presupposition that was. And I think you understand what I mean. I should add, too, separately, that I have a kind of unique and pointed hesitancy about Duke Law Review conferences. About 20 years ago, before moving east, it was my honor to do one of these lecture gigs, you know, where you come in and you give a talk, and there are a bunch of people who comment on how thoughtless it is, and then it's all published in the Law Review. During that venture, unknown to and unremembered by me, one of the commentators, along with the usual cast of professors, was a lawyer from the Solicitor General's office who had argued the case that we were discussing. He'd argued it before the Supreme Court. A little-known lawyer named John Roberts. When some decades later, Mr. Roberts, or Judge Roberts, was nominated to be the Chief Justice of the United States, this piece in the Duke Law Journal was apparently the only thing he had ever published. So it received ample attention. And I can add that the only thing we knew for certain before John Roberts became the most powerful judge in the world was that he believed my federal jurisdictional theories to be full of shit. I explained dutifully to the hundreds of reporters who called that this placed the new Chief Justice firmly in the mainstream of American legal thought. So I will try and prove that again this morning. I want to start with a second disclaimer. I am not I didn't realize, of course, that state debt could be fascinating to anyone. I'm not a state debt person. I'm not a bankruptcy expert. I'm not a state constitutional theorist. I'm not a local government expert. I'm not a constitutional historian. I'm not a student of South American federalism. I'm not an economist. I started to say that the only thing I know about debt is I'm against it, but then it occurred to me that that's not even true. So I have very little to offer on this front. There's a convincing argument to be made that I shouldn't be here. I have nothing helpful to contribute. If that's occurred to you, let me just say that I made the very point enthusiastically to our persuasive and tenacious conveners. Apparently, my role is to provide amateur counterpoise, or sort of maybe hysteria, from odd direction and perspective. And that's fine with me. We all have our roles to play in this life. I'm doing another panel later tonight on the Citizens United case, and there I have a similar assignment, unformed hysteria. So maybe this can be a warm-up. What might be said about me, almost as a practitioner, is that I have worked the legislatures of 3 states pretty hard on dollars and cents issues in education, in human services, and in taxation. Very different political cultures, Colorado, Virginia, and North Carolina, but on the fronts that I want to explore, more than a little similarity in results. I've done more than a little work on poverty issues, so it is through the lens of those 2 things that I'll focus, having none other. I suppose that puts me in the practical consequences side of this panel. I'll also concentrate more, I'm sure, than is typical or is even believed to be acceptable in a distinguished academic conference like this on the state of North Carolina. But as an excuse, Michael indicated a couple of weeks ago that he was going to be talking a good deal about Germany and Brazil and Argentina. So I thought I'd throw in another foreign entity into the mix, the state of North Carolina. It is, of course, no secret that state budgets across the country are extraordinarily stressed. I suppose there are 1,000 ways to suggest that. The huge specter of Medicaid obligations, looming pension commitments, the potent budget cuts more broadly that we have seen here the last several years running. Last year, about $2 billion in hard dollar cuts on a budget of $19.7 billion. Almost $500 million to K-12, $350 million to the UNC system, $432 million to social services, $165 million to law enforcement and public safety. Serious business. Second, to illustrate, I've seen it described now across the country, referred to as what is being deemed a, quote, public sector depression. Reportedly from 2009 to 2011, unprecedented levels of public sector job losses for 3 years in a row, soon to be 4. State job losses apparently at levels and for durations that have not occurred in many decades. Or here, another telling indicator, last week's front page headlines in the Raleigh News and Observer, exodus from state legislature grows, reporting on the former Speaker of the House, a widely respected legislator of 32 years, saying he would not seek election, joining 10 of his Democratic colleagues in the House, and I see the need to update that today with Jennifer Weiss, another of the strongest Democrats, announcing she wouldn't run, Linda Garou, a strong state senator, coming to the same conclusion. So at least a dozen members of the House, also large numbers of Republicans, suggesting perhaps that the job is less pleasing even for those in the new majority, and that the modest joys that come from severely cutting the budget of your adversaries are short-lived and less than completely satisfying, and that the pain cannot be cabined and restricted simply to unworthies. So it is tough duty for all. Now, if we're going to do a close examination of the stress encountered in state budgets by the difficulties of debt and recession and federal matching obligations and burgeoning demand, there will always be value judgments reflected foundationally within the dollar determinations that people like me reject and perhaps exploit. This year, for example, North Carolina accepted markedly deeper cuts to public education, higher education, and social services in order to allow a 3/4 cent sales tax provision to expire so as to remain precisely within the sweet spot of a no tax pledge. Another deliberative drawback is less predictable and maybe more systemic. Our $20 billion annual budget is depleted every biennium, according to North Carolina's 2011 tax expenditure report, by over $9 billion in tax expenditures. These figures have risen by over 50% since 2005. The Department of Revenue defines the undertakings as including, quote, exemption, exclusion, deduction, allowance, credit, refund, preferential tax rate, or any other device that reduces the amount of tax revenue that would otherwise be collected. I was delighted to learn recently, you might have been too, that various tobacco distributors get an impressive tax break if they choose to file their mandated reports and cigarette tax collections on time. Alcohol distributors enjoy parallel treatment. I scoured the 2011 tax expenditure report to see if citizens like myself, who filed their returns by April 15th, qualify for such cool largesse. I was stunned to learn that on this crucial front, I am apparently denied equal protection of the laws of North Carolina. There's a modestly larger and more serious point hidden there. States generally require a wide array of procedures and hearings and hoops and documents and findings and publications and the like to accompany their direct spending determinations. Tax expenditures usually get far less scrutiny, no matter how dire the budget chaos. They're also sellable as infinitely more beloved tax cuts. Most are written into the tax code and continue indefinitely. States don't usually document their effectiveness in the same way as on-budget expenditures. Without clear indication of a particular expenditure's costs and benefits, legislators either don't look or they grope in the dark rather than pressing for a more fully informed decision. Lawmakers' typical claims, particularly in dire budget terrain, that everything is on the table can be rendered less accurate than one would hope. The advent in now over 40 states, according to the Center on Budget and Policy Priorities, states like North Carolina, with the introduction of at least some version of a formal reporting mechanism for tax expenditures, is a sanguine step towards deliberation and transparency. I fear, though, that in many of the 44, certainly it's true in North Carolina, the requirement of a tax expenditure report has not led to anything like a careful review or justification for whatever might be in the reports. Our last legislative session would have looked markedly different had we, along with other massive direct spending cuts, taken a dramatic whack out of the tax expenditure side of the ledger. But finally, to a larger point, which is why I bother you to be here in the first place. We face crushing structural problems for a variety of reasons in our state budget process. That is true. But I want to spend a minute making a claim that bad as these truths, which will be much discussed here, are, they don't touch the most imposing challenge we face. That one, the scourge of intense poverty in the wealthiest nation on earth, won't be the focus of many State House discussions. I know it's fair at the least to say that they haven't made their way into the agenda of the legislatures I've worked with, in whatever state, Democratic or Republican, pre-session or post. The most pointed challenges of economic distress seem to remain largely beyond our legislative field of vision. It is rare, I'll concede, for a politician to put it as crudely as Governor Romney recently did. But the Washington Post, after the Romney hiccup, was surely right to conclude that it is a bipartisan truth that talking about the poor has fallen out of political fashion. We have, as you likely know, over 15% of Americans, 46 million, living below the federal poverty standard. In raw numbers, the most in our history. On a percentage basis, the most in about 3 decades. Distorted on the basis of age and race and sex. 22% of our kids, according to a just-released international study by the Organization for Economic Cooperation and Development, immensely imposing gaps or chasms of economic inequality between the richest and poorest segments of American society. Among the 25 OECD countries, much lower disparities, the report explains, exist in the Nordic and continental European countries. The highest polarization appears in Israel, Turkey, and the United States. The most notable increases in inequality over the past 25 years have occurred, according to the report, in the United States and Mexico, accompanied in our case, according to OECD, by one of the most modest safety nets among the advanced Western democracies. This parallels, in a sense, the conclusions of the Gates Foundation's massive rule of law study a year ago, comparing actual rather than professed or formal access to the civil justice systems of much of the world, rating the United States last among the wealthy democracies. We perhaps talk more about equal justice and comparatively do less. In North Carolina, it's worse. Almost 14% of North Carolinians live in poverty, almost 18%. Over 25% of our kids, over 40% of our Black, Latino, and Native American children. Numbers so embarrassing that they're hard to admit to ourselves, much less get our arms around. Communities within 60 miles of here to the east, in what used to be called the Black Belt, where more than 50% of the residents live in poverty. removed and separated from the drivers of North Carolina commerce. 10 counties between here and the coast, Bertie, Bladen, Columbus, Halifax, Martin, Northampton, Pitt, Robeson, Terrell, and Washington, meeting the federal definition of persistent poverty. Over 20% of their citizens living in poverty for each of the last 30 years, but you could have said the last 100 years. A new study by the North Carolina Justice Center finds, unsurprisingly, markedly diminished standards of education, housing, employment, infrastructure, and health care in these communities. In many, close up, it appears as if neither the civil rights movement nor the internet age has made appreciable impact. And as many of you know, we don't actually have to follow or travel very far to the east to find extreme, persistent, concentrated poverty in North Carolina. We have large groupings of census tracts revealing extreme poverty, people living at less than half the federal poverty standard. In the middle of Raleigh, Charlotte, Greensboro, Winston-Salem, and Durham. And as some of our recent Poverty Center work has demonstrated, the deprivation looks worse, not better, close up when you move past the bloodless statistics. Exploding demand at the food banks in Hosky, rife with employed, shamed, first-time users. Parents so desperate to secure food for their kids that they camp out all night long, midwinter, for scarce canned goods. Homeless shelters in Elizabeth City, presenting 26 beds in total for over 1,000 homeless women and men. Families without toilets in Gates and Hertford counties. Healthcare providers bending the rules in Rocky Mount to place oxygen in patients' homes to make it tougher under law for utility companies to shut off service to impoverished, incapacitated customers. School kids in Roper preparing to compete in a global economy like mine, but without access to broadband. Tiny, ramshackle houses with electric bills dramatically higher than much larger homes in the Triangle. Scotland Neck, where over 40% of the housing is substandard, out of code, but if the city enforced the rules, homelessness, already bad, would mushroom. As you might guess, I could go on, but to everyone's relief, I won't. I'll end only with 2 points, or maybe slivers of points. First, the very proposals to respond to our massive problems of debt, overcommitment, and federal intrusion, and crowding out and accountability, all assume, as you might guess, as I think they would have to, baselines of state and federal resources and taxation and expenditure patterns and the like, and then they seek to alter some or all of those to assure brighter skies. But those baseline results are built on a remarkably skewed status quo, for my money, an unacceptably skewed status quo for the wealthiest nation on earth. Second, how we respond and restructure ourselves to deal with state overextension is vital. There is no doubt about that, but it's not all. That's my point. It's not everything. It may not even be at the top of the list. Thank you.
So now we'll throw open the floor for questions. As sometimes done in conferences around the country, what we'll do is we'll take 3 questions each, sort of create 3, troika of questions, and then throw it open to the panelists to respond. So feel free to direct a question to a particular panelist or to the panel as a whole, and that way we'll hopefully get a little bit more back and forth between everyone asking. So if there are any questions for our panelists. Yes, sir.
Well, it was mentioned before that there's this, new way of securitization, and I'm not too familiar with securitization of state bonds, and I was wondering, to what extent is there that securitization of state bonds, and then just to kind of follow up on that, if there is this great extent of securitization for state bonds, has the Dodd-Frank done something to at least have those people who are making the securitization packages and then shipping them off to at least retain some kind of interest in that to kind of prevent this passing off of risk to investors, and then find a way to have some sort of market discipline to ensure that people are thinking twice before they're just going to package any state bonds and then ship them off to investors and ensure that there is no market discipline.
Okay, number two. Yes.
My question is for Professor Conti-Brown. To what extent is your proposal really just about California? Because state debt is certainly a problem everywhere, including a lot of states that don't have the extreme referendum system and the problems associated with it that California does.
Also, Professor Conti-Brown, you can enforce this mechanism that strips away laws. How do you prevent then, after the crisis has been solved, those laws coming back into play and being passed again? Is there a permanent injunction against, a constitutional law forbidding the raising of property tax?
All right, well, I'll jump in on the last two and as quickly as I can, so we can get to the more interesting comments from other panelists. So first, just California, no. California is the example that I use in the essay, and the example I use here. California is not the only state that has a constitutional amendment with popular referendum. I'm not 100% certain of my numbers, but I think it's something like 30 of 50 can amend the Constitution by popular referendum. What this would do would be applicable even to the other 20, though, of the 50 states. Again, this is about changing state law in a mechanism that can be done. So I guess in that sense, it would have to be tailored to the specific state and their ability to change and to change their law. So I think in that sense, it would be certainly through the mechanism I described here, a popular referendum is a threshold issue. But you could imagine tweaking the proposal in a number of different ways that would make it applicable to interacting with the state through the legislature as opposed to through the people themselves. And so again, this is the problem that I'm assuming that I think needs to have more research done about it, which is the extent to which this is a problem of excess law as opposed to excess debt. And that's the same answer to the other states if they have real problems with, I'm sorry, this was your question up here, right? Sorry. The question, again, just to reiterate, this is a question of excess law as opposed to excess debt. So if you've got state situations that find themselves much like a situation where you'd want a corporation to go through Chapter 11, they're an otherwise solvent corporation that find themselves on the bad side of a financial crisis, that some slight restructuring would take an otherwise viable institution and carry it forward, that this could be an opportunity. So in those kinds of situations, my proposal is inapt. This is really for a core dysfunctional legal system or legal apparatus that would need change. And then the second question of how would you keep this from happening? And you couldn't. There's no credible commitment that you can make to say, no, we've changed the Constitution, no, really, you can't do it. In many ways, the United States of America is an illegal entity. We're still governed under the Articles of Confederation because we didn't follow its regime for amendment or change. So, so you can't do anything. You can say till you're blue in the face that this is a constitutional commitment. You can't do X, Y, or Z. What this does is just, it's a do-over that allows for any accretion of excess law to extend over the long term that perhaps would have to happen again. And I think the reason why this might be superior to a model of only state bankruptcy is that it would extend that period longer. It's my assertion, and we could perhaps debate this, that the accumulation of debt would occur more quickly than the accumulation of law. And I can say just a quick word about Dodd-Frank. The securitization of state bonds, and I think Professor Johnson could speak to this more authoritatively. Understand that securitization is different than issuing bonds. Securitization takes a variety of other income streams, or perhaps even one income stream, and then sells claims on that income stream later on down the road. So the example that he gives that's so interesting is these Garvey bonds that are claims to future income streams from the federal government, which creates fascinating legal and political issues. But issuances of bonds they're securities, but they're not securitizations. And so the analogy between mortgage-backed securities and collateralized debt obligations, which I think you're referring to in terms of what Dodd-Frank does about mandating certain amounts of equity retained on the books of the issuers, isn't exactly apposite, though I'd be interested to hear what others said about that too.
I'm not an expert in municipal finance at all. What I've seen in the newspapers is that some federal agencies have made noises about supervision of the bond issuance process, because, I mean, if private bond issuers did what municipalities do by way of prospectuses and all the rest, they'd all be in jail, right? So it would be a good idea to have a little more transparency and compliance with disclosure obligations and so forth. I don't know how far that has gone, how hard these people have pushed. I really don't know.
Let me comment a little bit on Peter's suggestion, because I lived in Colorado for a long time, worked in the political system there, and which is also a very vibrant referendum state. I would, first of all, you might look and distinguish between places with initiative and those with referendum. Initiative being much wilder, coming directly without the input of the legislature. That occurred constantly in Colorado. So that if you're really exploring the sort of massive danger of too much law on this front, I think that would probably be concentrated in initiative states. In my time in Colorado, for example, there was not only a sort of tax, the Tabor amendment, but other sort of less well-known and for some less worrisome, but equally sort of difficult things. Determination that certain revenue streams could only be used for environmental purposes, because there was a powerful environmental constituency in Colorado. One set of proposals that I think did not get enacted, but which would say something like you have to spend at least 18%, 20% of the state's budget on public education, just a flat mandate. And working in the political arena to try and defeat such claims where voters are intensely uninformed about making the sort of balance that's required for that is hugely frustrating. And so, I mean, you identify a real problem. I'd recommend that there's the extent to which your proposal, I know it doesn't do this, but if it even sort of moves up next to a suggestion that the referendum process be limited, and that people lose the ability to vote for these initiatives. I know that you wouldn't technically do that, but I could imagine political objections that this would take away or limit your ability in the future to vote on initiatives. That makes something impossible to pass politically. If you say to people, we're going to in some way circumscribe your ability to vote on something which you now have. We had kind of remarkable proof of this in Colorado when I was there, I thought. Colorado has a partisan elected board of regents, which runs the university system. I'm no longer there, so I can say this with candor. It was conceded by all to be the worst possible system you could have. And it combined intense, petty intermeddling with a reality that no one in the world knew who they were voting for these statewide regent elections. So we did empirical research at the university trying to do something about this, and found this. Fewer than 1.5% of Coloradans had any idea who they were voting for on these regent races, and about 97% conceded that the regents were horrible. They just did a deplorable job. Then when you follow that up with a statement, okay, let's change and no longer elect the regents, they said, hell no, why would we possibly do that? Just because we have no idea who we're voting for and the system is deplorable, that's not a reason to take away the right to vote for it. So I'm not sanguine if you run against that political hurdle that's capable of being overcome. So.
Okay, more questions? Yes.
Yeah, I have a question about the proposal as well, and really more kind of the practical. It's promise for kind of practical application, because as I take it, and you described it nicely as dealing with too much law, not too much debt, it really isn't at all a way to restructure or discharge or deal with any debt whatsoever. The only financial benefit that would come from passing the referendum is that it would free up federal bailout.
Yes.
So, and we're assuming, or at least I take it you're assuming that it would be more likely to pass in kind of moments of acute crisis when the problem is salient. And let me just say, I love I think it's a great proposal, but I'm worried that at that moment, when there's a salient acute crisis, what people want is they're concerned about the financial dimension of the problem, right? So then if their obligations, they're unsustainable, that's the salient question. And maybe the bailout will help to address, to make payments that are coming due, but not deal with the underlying problem. So I see both a kind of political and maybe a kind of moral hazard problem. The political problem being you're asking citizens to then vote for something to undo things that lots of them fought really hard to do in the first place for just the bailout and not any debt relief. In the backdrop where many of them might, I think perhaps rightly think that even if they didn't pass the referendum, the federal government isn't ultimately going to withhold the bailout. So maybe you have a kind of no bailout pledge problem as well, that if it becomes an intractable or even difficult and divisive political problem, that people might be inclined to punt and hope that they'd be rescued anyway, which isn't implausible.
Yeah. Professor Blair?
This is a follow-up to Adam, which I think goes to Peter and maybe spills over to Michael. I think, Peter, since you asked for potential constitutional problems, I think that the conditional spending goal problem might actually be a little harder here because of the coercion argument here. So the goal, it was fine to condition spending because it was only like 5% or something. It's not a lot, the federal highway funds. What we're talking about is withholding federal bailout money, the scope of which I imagine is much larger than 5% of the federal budget. I think there might be a constitutional problem there, which we won't really know, I guess, until we get the ACA decision in July. But since the court has added an extra hour of oral argument time to talk about the problem, it may end up being complicated. And then the spillover to you, Michael, I guess, is that I wanted to hear more what you think about the coercion argument, because it sounds to me that you're extremely skeptical of that. It sounds like that you think the states are being given too much encouragement and incentive and not coercion. And so as a policy matter, this looks horrible to you, but as a constitutional, at least coercion matter, this doesn't look problematic. Is that accurate?
And then third questions? Yes.
I'm trying to figure out if what Mike Greve said implies what I think it said. It seems to me that what you're saying implies that any federal aid to the states for a joint program that is fungible is a breakdown on the pre-commitment not to bail out state finances. Is that correct?
It will have that result.
That's pretty startling.
Even short of 100%.
Even short of 100%. Yeah, it's sorry.
No, please.
No, my point is that once you start a federal transfer program, which is not a bailout at the front end, right? It becomes much harder at the tail end for the federal government to say, sorry, we've incentivized you to spend yourself into oblivion, but we won't help you now.
So would you have a recommendation for some kind of constitutional principle or constitutional language that would embody your recommendations for maintaining the pre-commitment not to bail out states?
Sorry, should I?
Yeah, go ahead. Please.
Help. I'm very skeptical of it. It's a terrific question, and I've noodled over it. What might that look like? The reason why I'm skeptical of it is that lots of federal systems have formulas, constitutional formulas that say no bailout ever, right? That's, for example, Article 125 of the hilariously named Treaty on the Functioning of the European Union, right? It's an ironclad no bailout commitment. Did they find a way around it? Sure they did. I mean, they've now found a way around it twice, right? On some ludicrous solidarity clause that, you know, came from nowhere. And the interesting thing about the United States Constitution is there is no prohibition against bailing out states, period. And that is closely linked to another piece of genius in the United States Constitution. It has no fiscal constitution at all. That is to say, it has no prescribed funding formula in accordance to which state and local governments have to be funded. Almost all federal constitutions in modern era have those. Germany is a celebrated example. Argentina has that sort of. Brazil has it. And that's a prescription for disaster everywhere you look. And what stabilizes the no bailout commitment, or traditionally stabilized the bailout commitment in American politics, I know this is an ugly thing to say, but it has to be said, was sectionalism in American politics. First connected to slavery, even after the Civil War, sectionalism remained an enormously potent force in American politics. And so you could not find a way to rope states into a federal spending cartel because everybody wanted to know which way is the money flowing, right? And it was just too divisive. And so all of the bailout, all of the funding proposals that were out there failed precisely for that reason. The bailout in the proposed bailout, there was a proposed bailout in 1842, and it failed because they couldn't agree on a formula. They said, okay, fine, why don't we do this in proportion to population, right? Because that also isn't in the Constitution for spending, but it's at least there for direct taxation, so that's the reference point. And the next question then is, if you propose to do it in proportion to population, before you get to the point, that has nothing to do with culpability and spillover effects and all the rest of it. The question is, are you going to count the slaves, yes or no? And everybody said, ooh, oh, you know, that we don't want to go anywhere near, right? And so what changed in American politics is that the New Deal created political technologies to overcome the sectional division in American politics, to rope states into these tax and spend cartels, and then the game is up and there's no coming back. And the only thing you can do now is, I don't think you're going to change that sectional and political dynamic by means of constitutional prohibitions that you write into law. I don't think that's it at all. You have to do one of two things. You either have to sort of recreate or try to recreate the sectional dynamics, hopefully this time around without slavery, that once upon a time stabilized the system, or else you have to find a way to segregate the functions that states and the federal government respectively perform. And if you ask me, that would be my position. I am a vehement defender of nationalizing Medicaid for some of the reasons that now it comes that Gene Nichols mentioned. It is a disgrace that a rich country like the United States cannot provide medical care to its poor people or to whoever you want at an acceptable price. And one of the reasons why that is this forsaken transfer system that bottles up, that gums up the whole works and where, the bureaucracy siphons off enormous amounts of money that is supposed to reach the intended beneficiaries and does so only intentionally. If you can manage that, and we're very, very close to it. Once we're paying 100 cents on the Medicaid dollar anyhow, bail them out, put it on the federal budget, and be done with it. And then give the money to poor people. Don't give it to places, for God's sakes.
Before we turn to Mr. Conti-Brown's answer, I do want to point out, interestingly, I'll exercise the privileges of moderation to say that the one place in the Constitution that does restrict the federal government bailouts of states is Section 4 of the 14th Amendment,
yes,
which prohibits the U.S. or any state from assuming or paying Confederate debts after the Civil War. Mr. Conti-Brown.
Yeah. So I just want to pause and note that something very special happened here, that Gene Nichol agreed with the American Enterprise Institute. I remember where you were when you heard this, because it doesn't happen often. So the three questions I wanted to respond to, first Professor Nichol, is does this get rid of the initiative? And it doesn't at all. This proposal would not. In fact, whatever my views, which are fairly inchoate about the strength or weakness of direct democracy, is an acknowledgement that that's not going anywhere. That the likelihood of getting the people to give up so powerful and direct a participatory weapon is unlikely to succeed. To Professor Feivelman's point about what this does, so it would not clear away debt in the way that the state bankruptcy regimes that have been proposed would do. But it would in any way that could be done by statute or the Constitution. The biggest problems with that, of course, are going to be the U.S. Constitution's contract clause, which will prohibit adjusting contracts without the participation of counterparties. And so in that sense, it absolutely would be shackled. What I see this being then is a complementary proposal to those state bankruptcy regimes that would treat the debt problem. And the reason why I think that this is, as I mentioned, this is a solution in wait for the problem, is because I'm not convinced. I think Michigan is a great example of this, that the current legislative mechanism for dealing with fiscal crises is so irretrievably broken as all that. Michigan, I'm referring to the fact that Michigan has turned a budget surplus, and to say that 5 years ago, the state of Michigan would be turning several $100 million budget surplus would have sounded like science fiction, but there they are. And so I think that connection would, I agree with you that were this a unified theory of state fiscal crises, that it would fail in that regard, and I don't see it as such. I see this as being focused on a very specific problem to the extent that there is this specific problem, and being a solution that state bankruptcy regimes don't touch. And that is to adjust this accrual and accretion of state law. And the last with Professor Volker, I think it's an absolutely fascinating question in the Dulg and South Dakota context of what constitutes coercion. Because for that argument to work, it's got to say that there is some sort of almost quasi-entitlement to federal bailouts in order for there to be a coercive mechanism. And as you look at the facts of South Dakota, again, this is a question that the federal government wants to fund for interstate highway construction and maintenance, and says in order to get these funds, you have to have a drinking age of 21. South Dakota had 18. And this was deemed appropriately close enough that the interest in maintaining highways was close enough related to the drinking age that it passes muster. And the interest here is the interest in keeping states from knocking on the door of the federal government to get bailouts and saying that if you want to do this, that's fine. You've got to make changes so that you're not just going to be coming back here next year when your tax revenues are similarly maladjusted. That's not, in my mind, a no-brainer. This would be litigated. It would be litigated on spending clause grounds, and I think that would be an opinion which, if I'm going to be frank, the likelihood of this ever becoming policy is between 0 and nothing. But the idea, though, that resulting opinion would be a fascinating one, because it goes to the meaning of coercion at a time when what constitutes the state's right to federal funds is as Dr. Greve has pointed out, in flux.
Go ahead, Mike.
Just because you asked about coercion, my position on the Medicaid coercion theory and on coercion in this context is that I believe the state's complaint in that case borders on the frivolous, putting aside that, modest position. Look, I would urge, let me just say the following. as long as I've been around in Washington, which isn't all that long, but it's a lot longer than you've been, you know, alive. The conservative mantra was unfunded mandates, that destroys the federal balance. Unfunded mandates, we can't have unfunded mandates, right? That was the complaint. Now it is, look at Paul's complaint in this case. They are paying us 100 cents on the dollar, and that is coercive. It's a funded mandate. How dare they? That destroys the federal balance. Now, could we please all agree, sort of at the front end, whose side we're on here before we yell about coercion? It's just a modest proposal. Okay. Now, he is in terms of Peter's proposal. I don't view this as a sort of coercion problem, because quite probably, if there's enough money on the table, and I believe this will survive the Obamacare litigation, if there's enough money on the table, yeah, there can't be coercion. The state, right, consents to it. What I think there is, or maybe, is a delegation problem. And the reason is that and this is no longer very fashionable, but I believe there are still functions that the federal government cannot delegate to states. To use Professor Tribe's example, you know, having agreed, I mean, that's all lost anyhow. I've already agreed with Jim Nichols. Now, you know, let me agree with Larry Tribe. The federal government could probably not delegate power over the nation's air corridors to the Massachusetts traffic authorities, right? Because it's inherently a national task. There are certain things that states probably cannot delegate to the federal government. On what authority am I saying so? New York versus United States, right? I believe it's page 182. State consent doesn't cure the problem here, right? Once you say as a state, thank you very much, federal government. Here is our entire government apparatus, and we hand it over to you, right? Including all the referenda that we've collected and carefully built up over the years. And you figure out what to do with it, and then you give us the beast back? I think that's cutting it close. But I'd have to know more about the mechanics, but I don't think the delegation problem is trivial at all.
No, I agree with you. And as I was struggling through this idea, that's why the state authorization happens at two junctures. One is the please help us, federal government, redo our fiscal law, constitutional and statutory, to which the government responds effectively as a group of armchair academics saying, here's what we would do in 500 pages or 5,000 pages. And then the state comes back and says, do we want to do this? Yes or no? What the federal government says, if you want bailout, you've got to say yes. If you say no, then, you know, good luck, enjoy, and sort this out, which, again, I don't take to be a flippant response. I don't think necessarily that would be all too terrible a thing. And there's also nothing stopping the state, either by popular referendum or by its usual representative democratic mechanism, of saying, we hated half of that report but loved the other half. Let's vote seriatim on the other half. Let's either by, again, popular referendum or initiative or by, through legislative approval. And it's that second approval that I think takes care of the delegation problem. But I would be interested to hear other views on that.
You know, Peter, you also have the advantage now, which of course is an intense political disadvantage, but this has become so complicated you could actually call it a 12-step program, which would be set to cure other sorts of addictions. A couple of things I wanted to add. First of all, that I not only like Michael's position on Medicaid, but I love his accent. But even better, I don't know if you've noticed his accent when he's discussing Republican politicians becomes this hugely demeaning. So, cool. There's a couple of interesting counter political points, I think, in this. First of all, if we distinguished between what someone like me, anyway, thinks of as a traditional, real, full-scale bailout, a California bailout, a single state bailout, in other words, instead of some action by the federal government which may affect many, many states or all states at once, like 100% Medicaid program. I've always thought we have just an almost unbreakable political barrier in the United States to such bailouts. I was up in Washington once when there were some discussions about what they might do about California or other occasions, New York, and the possibility that you could get the other 49 states to vote to bail out some hated entity like California has always seemed to me at least to approach the insurmountable. So we may have a sort of political structural difference as opposed to the EU. Then there's a kind of odd counter political move too with, I agree with a lot of what you say about the, what becomes sort of veiled bailouts. But curiously, that's accompanied by a very strong and repeated desire amongst those who are trying to limit the expanse of federal programs to say, okay, I want to block grant this program and send it to the states. And then in major part, the theory is once I block grant it and send it to the states, I'll be able to ignore it at will in a way that I can't ignore it right now. So we have these kind of interesting cross-political currents on these things.
Professor Young.
So, Michael, I've been trying to think through your argument, and it seems to me your objection is fundamentally to cooperative federalism. That the reason why the federal government has to bail out the states is that the federal government now, since the New Deal, maybe since the Great Society, fundamentally depends on the states to enforce federal law. So if a given state, California goes bankrupt, then all of a sudden it's not only state policy that isn't getting enforced, it's also the Clean Air Act and the Clean Water Act and the health care law and all these other federal programs that can't get enforced. On the other hand, if that's the reason that the pressure for the bailout comes from, then the moral hazard argument that the part has become able to commit the whole becomes less compelling, right? Because it's really what's driving the debts of the part is the fact that they're working for the whole, right? Now, I see that there are certain things that the states are driving up their debts that aren't part of what they do for the whole. And I think about, public pensions, for instance. But and so it would be, you'd still have, it'd be incredibly problematic for the no bailout guarantee to be eroded as to those sorts of things. But I wonder if the pressure to bail out isn't correspondingly less for those sorts of things. So it seems to me a more modest version of your proposal. We don't have to return to dual federalism because that's not going to happen for lots of jurisprudential reasons, is to try to figure out some way to design the federal cooperative federalism process so that the incentives to bail out are tied a lot more directly to the federal inducements that send the states into certain kinds of debts, so that any federal bailouts that happen are going to be targeted to the things that maybe the federal government ought to be responsible for anyway. Right? And that doesn't seem like an insurmountable institutional problem to me.
Question number 2. Failing a submission, I'll ask my own, which is to Peter, which is sort of part of the question here is the timing. Crises happen sometimes quickly, sometimes without a whole lot of warning. And it would be a little tough, I think, if we suddenly discovered sort of California, suppose California, like Greece, were having a debt rollover on March 20th, and we were suddenly very worried about its ability to do that. I don't know that you could get 2 referendums and a 5,000-page plan out between now and then, and have any sort of meaningful deliberation about it beforehand.
You do know.
Yeah. Especially the referendum on the back end. I think that's what's hardest, because you don't know whether the plan will ever need to be amended, and you don't know whether sort of new things may be asked of you, and if there's sort of a two-stage referendum, it takes a long time to vote on things. Mm-hmm. And so what I'm wondering is, are there ways of dealing with that problem? Would it be better to have a version of sort of federal receivership that just sort of hands the state budget keys over to somebody else for a period of time so that you don't need to keep going back? Or would that drive you into greater legal concerns? So now I'll ask for number 3, if anyone's got one. Okay, well, why don't we start with 1 and 2?
Ernie, I hope I'll answer this and ask again if I'm not so fully answering the question. My impression of cooperative programs over the decades is that they're iterative attempts to get the incentives right? And all that happens within these programs is that they sort of fluctuate from, hey, let's block grant this, right? Because there are all these warped incentives in all the federal regulations and so on and so forth. It would be much better to give states flexibility. And then it turns out you give them the flexibility, and one result is the spending goes up, not down. And the second thing is there's lots and lots of substitution effects that you really don't want. And so you go back to maintenance of effort requirements and recategorization and so on and so forth. And so the system goes back and forth. And what changes is sort of the balance of forces and the terms of bargaining among the levels of government, but no net effect on, no real big effect in terms of the outcomes. And the second thing is that I think it's very hard to sort of insulate or cabin these programs in silos, right? They all have displacement effects and they all rattle through the system, and then kaboom, the deaths show up in the pension system at the end of the day, right? That's how, and the more generous you make the federal program, the greater the displacement effect and the greater the tendency to sort of push off the debt problems into other areas. Having said that, I do agree with you in one very important respect, and I'm grateful you brought it up. This is not a story about you bad and evil state politicians. This is also a story about what the feds do in terms of irresponsibility and sort of driving the states to sort of very counterproductive behavior. The reason why that deserves, or one of the reasons why that deserves emphasis is not sort of, let's be fair to all the politicians, but it's this, suppose, and I've sort of noodled over this. This plays a very big role in the state's Medicaid complaint. And what Paul Clement says, and he's right about this, is that, look, the coercive effect here is that if some state wanted to withdraw, it would still have to pay, its citizens would still pay the taxes. Two reasons why that doesn't really help him. One is that was litigated in 1923 and that didn't go anywhere. And so, if you want to raise that again, good luck to you, but I won't try, and he knows better than to try. And the second thing is that, of course, that's true of every one of these programs and not just of the Medicaid expansion. And his whole game has to be, it's just this expansion and I'm telling you how it's different from everything else, right? But that doesn't mean he's wrong as a matter of empirical fact or the political economy of how the world works. And so I've noodled over things like, suppose we had a federal law, either generic or attached to, you name the program, that says for any state that opts out, the taxpayers will get a proportionate rebate against their income taxes. So that if North Carolina says we're out of Medicaid, everybody gets a 7% income tax cut come income tax time, because 7% is roughly the proportion of Medicaid in proportion to the federal budget. I'm not sure what the response would be. I'm not sure that, given the entrenchment levels that these programs have, that any state could opt out. Right. But what you would have is a much more open and candid debate at the state level about, do we want to be in this program or don't we? Is it the right thing to do to devote 25% of the budget in this state to Medicaid? Come on, you can't be serious, right? So you'd have very different dynamics. And one of the reasons why the federal government, I think, would never contemplate a proposal like that is, one, it makes sense, right? That's the first strike. And the second strike is that they fear what you just mentioned, which is, this is our way of having our way in the states. And if all of a sudden, you know, these people are allowed to opt out, who knows what might happen? Freedom might break out.
If we had the opt-out proposal, then you would have moved from the very congenial idea of universalizing Medicaid and making it federal to abolishing Medicaid, because every state would, well, certainly North Carolina would opt out.
You think so?
With bells on, yes.
Is that right?
A vote by the majority of people about whether they should pay 7% of their income tax to go to poor people? Not close, sadly, not close. Well, I hope you're right. That'd be great. I was also going to mention about Steve's suggestion of a federal receivership, which I find appealing for a completely irrelevant reason. That is, I'm a constitutional law professor. If we had a federal receivership, then we would finally dust off the Republican form of government clause and use it. I'm opposed to clauses in the Constitution just sitting there fallow. So maybe we could have the privileges and immunities clause of the 14th Amendment and the Republican form of government clause, which would get in the way of such a receivership, I think.
Can I just, this is so fascinating factoid. So these temporary receiverships is actually how these things are run in Argentina. So some province goes bust, the feds stroll in and say, we'll clean this up, we'll throw the people who did this to us or did this to you in jail. And then they depart a year later, and the people who are in jail are getting out again and getting themselves reelected, because that was the point of the exercise. And pursuant to what does the federal government do this in Argentina? And you have to know that the Argentinian Constitution of 1853 was a carbon copy almost of the American Constitution. And this is being done in Argentina pursuant to the Republican form of government clause, because they say, whatever Republican government is, you don't have it. And, you know, if it comes to California, I'm close to agreeing.
Well, I, as a bankruptcy and banking scholar to be, I will not wade into letters of marque or the guarantee clause of the Constitution too squarely, except to say that, you know, Steve, your point is extremely well taken. The timing issue is a hard one, and my answer to that would be twofold. The first is, again, this is about law, not debt. So this can't be a grand unified theory. If you're going to talk about an acute fiscal crisis, the acute fiscal crisis is the debt crisis, not the law crisis. Those, again, is what I'm saying, are branches, though not roots. And so these would, one would accompany the other. And so the kind of federal receivership you're talking about, your colleague Stephen Schwartz has talked about a minimalist state bankruptcy. It looks not unlike it wouldn't be a federal receivership, except to the extent that the bankruptcy court would be replaced by a federal agency that would adjudicate some of these concerns, and otherwise it would just be a space in which the state and its creditors could work through some of these questions. Now, the second point, though, that I'd make is that there's much of this that could be done preemptively. So under the proposal I have in the paper, it is that the federal authorization would not happen in times of crisis, and frankly, the proposal could be adjusted, although I don't describe it in this way at present, to have the state initial authorization be outside of times of crisis, such that a report could come out of the Fiscal Restoration Commission well ahead of anything and say, look, Californians, you've got to stop screwing around with your property tax limits. You're paying less than 1%, whereas the national average is many multiples of that. And at the same time, as important as it is just examples, I don't mean to passing judgment on any of these specific referenda, but at the same time, the idea that the state government can't have access to hotel taxes in Los Angeles because they're based in Los Angeles as opposed to just some unincorporated space of California is preposterous. That's got to be changed. Those kinds of proposals could be floated ahead of time, such that outside of the fiscal crisis, say, hey, if we turn this over to the FRC, their report is going to say no more referendum barring the state government from taking local state taxes or local taxes, and it's going to say that this cherished proposition that limits our property taxes, some of the lowest in the state, is going to go out the window. So I think that it's not simply a question of debt crisis happening right now, 5,000-page report comes, no one has time to read it, we've got to approve it, it's time to go. That would raise some very interesting coercion problems. I think what it says instead is, we are at a crisis, there's got to be some other mechanism for treating the debt aspect of it, but while we're here, in the words of Rahm Emanuel, let's not let this crisis go to waste. We also have a problem with excess law, and I think that's the way that might be navigated. But the precise political issues, I mean, I'm so pleased not to be either a politician or someone who has to actually interact with these kinds of constituencies the way that Professor Nichol has done, because I find it to be so bafflingly unpredictable. The idea that, for example, a law review article becomes one of the most hotly contended agency creations in administrative law and popular political discourse is still something that I just have to pinch myself to realize is actually happening. I'm talking, of course, of the Consumer Financial Protection Bureau. And so I plead utter ignorance as to the political possibility and plausibility of some of the finer points. And I think it instead is kind of the role of academics to look at the corners and the cobwebs of some of these spaces, even while the political spotlight is fixed in other places.
Well, thank you very much to all of our panelists and to you for coming.
Produced by Duke University, online at duke.edu.